In today's courtroom drama, a landlord-tenant dispute takes center stage. David Pata seeks eviction from Seth Barton, but the case isn't just about moving property. It involves damaged materials, livestock, and a flood-damaged home. What seemed like a simple eviction quickly turns into a tense negotiation over deadlines, counterclaims, and responsibility.
David Pata versus Seth Barton.
Good afternoon, Your Honor. Paul Fester on behalf of Dave Pata.
Your name, sir?
Seth Barton.
All right, where are we on this?
If you recall, 2 weeks ago, Your Honor, you allowed my client to get a storage pod to move the property out of the house. He ended up not having to do that.
The hearing opens with David Pata's lawyer requesting eviction, claiming most of Barton's possessions have been moved, but the house and some property remain. The judge listens carefully, noting the complexities beyond simple removal, including the livestock and personal belongings that still need proper handling.
Tenant actually moved a lot of his possessions out of the garage right away, which allowed my client to take the items from inside the house and put them into the garage. So we did not have to go through the storage pod procedure. Defendant has got a lot of his possessions off the property at this point. The garage is mostly gone. The vehicles are mostly gone. The property inside the house doesn't appear to have been touched very much, and the livestock is still there as well, which my clients have been taking care of for the last couple of weeks. So that's where we stand. We're asking for a judgment of eviction and have him get the rest of his property out within 10 days.
Sure.
Barton explains that much of the remaining material was damaged in a flood. He mentions insurance coverage, a sanctuary for the livestock, and his plan to clean up and move the items responsibly. The courtroom tension rises as the judge weighs these claims against the eviction request.
I'm still moving the rest of the stuff out. It's quite a bit of material, as was described. I think one thing that's been overlooked through this case was that I've actually known Dave for almost 20 years. He knew what I was bringing to the house when I moved in there. This was not a surprise to him, even including the livestock animals, which, as a fact, they're currently, I'm working with a sanctuary to take possession of them. I hope to have them removed this week. And I was planning on bringing a dumpster to remove all the material that was destroyed during the flooding of the basement from the pipes breaking. If that's still acceptable with Your Honor and Mr. Peta, that was still part of my plan.
The judge probes why no formal counterclaim has been filed yet, given Barton's claim of over $40,000 in damages. Barton explains he is still inventorying the destroyed material. This back and forth highlights the legal and procedural hurdles tenants face in complex eviction cases.
Clean up all the damaged material that the insurance made us hold on to until the claim was resolved. As far as the destroyed material, I'm still accumulating a list of value of what was there that was destroyed that my insurance is not covered. And I did plan on presenting a motion to try to have that rectified as well to get this brought to closure.
So, when you say bring a motion, I'm not sure what you mean by that.
During my initial response to their asking to have me.
The judge observes that Barton had ample time, but delayed action until forced by court orders. He notes the garage was emptied quickly only after a pod was threatened. This moment underlines the courtroom reality. Deadlines and pressure often spur action more than warnings.
I stated in there that there was $40,000+ worth of material that was damaged during the flooding and the breaking of the pipe. My insurance company only covered $20,000 of it. It was their direction that I should try to sue Mr. Pata and his insurance company to get the remainder of the amount of lost material.
So, why hasn't that counterclaim been filed as of yet?
because I have not finished inventorying all the damaged material from the house as I've been moving it out, Your Honor. I could put it in right now, but it would be a partial value. It wouldn't be the total amount of what's been destroyed.
Well, but you at some point have to put plaintiff on notice of the claim. And, okay.
Your Honor, there's nothing preventing him from filing. I mean, this is because it's landlord-tenant law. We're in a unique area here. He doesn't have to bring it up at this point.
Well, he actually, oh, go ahead.
Well, my client is probably going to be bringing a complaint after all the calculation of the damages caused by defendants' use of the premises. There's been no counter complaint filed. This has been in front of the court 3 times. This is the first we've heard of it. If he wants to bring a separate action, he's free to do so. But I would just ask that we enter the order of eviction today.
Well, I don't think I'm going to do that. When are you going to have your counterclaim? Let's just get this done. I mean,
I plan to have the rest of my stuff moved out and inventoried with the end of the holiday here, Your Honor. I'll have some extra time off of work. I already have trailers lined up rented to get the remainder of the material. I've rented a storage unit to where I can place the molded material so that it's not contaminating.
So, sir, you know what? You give me these reasons and everything, and it seems to me that until you're pushed to the edge of having to do something, you don't do it. Because
The judge sets firm deadlines. All property must be removed by November 28th, 2025, and any counterclaim must be filed by December 1st, 2025. Any property left after that date will be deemed abandoned. This clear directive emphasizes how courts balance fairness with urgency.
We were here before and you were giving me every reason in the world why it couldn't be done. And then the moment I said that there's going to be a pod put out there, all of a sudden, the next thing you know, you can empty a garage. So I think you can get this stuff out of there. You can do that, and you can do it in, I think, rather short order. I don't think it's what you're claiming it to be to get that property out so that the property can be repaired and looked at.
I also didn't acquire a new place to live until Halloween was when I closed on a new house. Prior to that, I was living out of a hotel with my son.
Okay, I wasn't asking for an excuse. I'm just telling you what my observations are. So when is the rest of this stuff that you want going to be out of the premises?
By Thanksgiving, is that acceptable? 1 week from today.
Finally, the judge adjourns the hearing to December 5th, 2025 at 3 p.m., leaving room to address any filings. Barton explains logistics for moving the remaining property, including rented trailers and storage. The courtroom ends with a sense of resolution, though final outcomes depend on compliance with these orders.
I'm going to order. If the defendant is going to file a counterclaim, he's to file that counterclaim no later than December 1st, 2025. I'm also going to order that the defendant shall remove all property from the premises which he desires to claim. He's to do that by November 28th, 2025. Any property left on the premises as of 12:01 a.m. on December 1st, 2025, this court will indicate shall be deemed abandoned and may be disposed of by the plaintiff. All right. I think that will solve that. I will then adjourn this proceeding so that I realize it wouldn't permit time for an answer, but I'm going to set this for December 5th, 2025. What time?
3 p.m.
At 3 p.m. And I'm doing that. If he doesn't file, certainly, counsel, I would entertain your request for relief.
Thank you.
All right. Thank you, folks.
This case illustrates the complexities of eviction disputes. Damaged property, counterclaims, and logistical challenges can turn a straightforward eviction into a multi-layered legal battle. Deadlines and court orders ensure accountability, but the human element remains at the heart of every decision.